Greetings to all. Welcome back to our YouTube channel. Myself Sanchita Sanand, a first year law student from Galgotia's University and currently working as a legal intern at LEXIS and Company. So today I am here to talk about right of private defense. Nothing is an offense which is done in the right of private defense. Private defense can be defined as an act done in protecting one's body and property from other person when there is reasonable apprehension of receiving injury or any damage to one's property is considered to be as a private defense. In general, private defense is a general exception which speaks about the defense which one can take for saving his own life or another person's life and property only when there is a necessary condition or the steps that are required to be taken at the particular time and at the particular condition. So the main objective of private defense taken by accused should be to only defend himself but not to just providing unnecessary harm to other harm if the defendant is not able to provide any harm to the plaintiff, and it should be reasonable to take any action harming defendant in plea of private defense. The burden of proof is totally on accused that why he had taken such actions and what were the conditions that made the plaintiff to take such necessary steps to defend himself. So, right of private defense is defined into two parts. First, that is according to section 97 of Indian Penal Code, every person has a right to protect his own body and therefore the body of the other person against any offense affecting the physical body. Second, the property, whether movable or immovable, himself or of any other person against any act which is an offense falling under the definition of the theft, robbery, mischief or criminal trespass, or which is an attempt to commit the same. Right to private defense to the body. The reason and objective of taking private defense should be taken to protect the body. So the main reason to take private defense is to protect one's body when there is only reasonable apprehension of danger to the body of a person that arises from an attempt or threat to commit the offense through the offense might not are committed and it still continues as long intrinsically apprehension of danger to the body continues as mentioned in section 102 of Indian Penal Code. So according to this section, it generally states that whether there is immense need to take the private defense to protect oneself from any harm to the body in the form of any offense or any harm from anyone. The threat must give rise to imminent danger but not distant danger. The next phase is that of continuance, which permits the action to be in motion until the apprehension of danger continues. Private defense regarding private property. So private property can be legally defined as property owned by private parties, essentially anyone or anything other than the government. Private property may consist of real estate, buildings, objects, intellectual property upon which every individual has the right to defend his property from getting harmed or stolen from another person. The main reasons and objectives for private defense should be taken regarding property. The main reason to take private defense to protect its property is that when there is only reasonable apprehension of danger to the property arises from an attempt or threat to commit the offense on the property of the person, though even the offense has not been committed yet as stated in section 105 of Indian Penal Code. The plaintiff can only take action up to the point of time when the defendant is within the reach of the plaintiff. That is, the defendant is able to be caught by the plaintiff at that moment only, not after the defendant is out of the reach of the plaintiff. So the offences for which the private defense for the property can be taken are: first is robbery, then house breaking by night, theft, house trespass. So limitations of private defense of the body and property are: The defense to body and property will only be applicable if there is reasonable apprehension of fear and harm that is felt by the plaintiff that can cause him any harm within all suitable condition and can get harmed by the defendant. However, there are certain limitations to this right which are defined under section 99 of Indian Penal Code, which limits the scope of using private defense to be used to protect oneself. So what are the limitations? First is that any act done by public servant in good faith. Second, any act done when there is no reasonable apprehension of death, of grievous hurt or death by defendant. When there is time to have recourse to the protection of the public authorities. So, the right of private defense is obtainable when there is a reasonable apprehension of danger. It's important to note that the right of private defense is obtainable as long as recourse to public authorities isn't possible. No case of reasonable apprehension could even be made if, within the given situation, the assistance of public authorities are often obtained. Moreover, this general exception that private defense should be used only the plaintiff feels the reasonable apprehension of fear of injury or harm from the defendant, and therefore the defendant is in a position to supply any harm to the plaintiff. That is, the defendant must have all the acceptable condition to harm the plaintiff. Nothing is an offense in private defense, but nothing may be a defense or exception when there is no reasonable apprehension of fear and injury of body and property. So this was all about right of private defense. Thank you so much for devoting your time and listening to my video. If my video was really helpful, then please like, share and comment. And do subscribe to our YouTube channel Lexcliq for more upcoming such videos. Thank you so much and have a nice day.